This is Anti-Corruption Scotland Live. We're going to cover a document here for the people to know the rights. There is a statutory legislation, law and a common law system. And what's happening is there's an enactment. Statutory law is an enactment extension of the law, but common law is the main facts, plus common law is case law. Now, this is a document here, Rice v Connolly 1966. The last time this case was used was on March 17, 2019. Now people, it's important that people listen to this. It's fact, it cannot be rebutted. At common law, there is no legal duty to provide the police with information or otherwise to assist them in their inquiries. Lord Parker set out those questions to be answered when asking whether there had to be an obstruction of an officer in the execution of his duties. The first question was there an obstruction of a constable? Remember this, people, there is two statuses, and this is the part people keep missing out. Officer, constable. Officer is a policy enforcer to enforce statutes for a government, a fictitious entity, right? Number two, was the constable acting lawfully in the execution of his duty? Legal, lawfully. This is the other important part. Legal is to do with the person, lawfully is to do with a man or woman at common law. And the third question was obstruction intended to obstruct the constable to exercise of his duty, right? Now, Lord Parker, CJ, said it was also, in my judgment, clear that it was part of the obligations and the duties of a police constable to take all steps which appear to him necessary for keeping the peace, for preventing crime and protecting property from criminal injury. Now that's quite a strange comment. Protect property from criminal injury, right? I don't know. I know that you can property damage, but criminal injury, you can't injure the property, you can only damage it. There is no exhaustive definition of the powers and obligations of the police, but there are at least those, and they would further include the duty to detect crime and bring an offender to justice. Now this is an important part. In these documents, people, there's used legalese, trickery of words. Offender, accused, is person. It is not a man or a woman. So let's be crystal clear on that. And this is where I shine, because I understand what's going on here. A lot of people don't. It seems to be quite clear the defendant, another trickery word, people, defendant is a person. The defendant was making it more difficult for the police to carry out their duties, and the police at the time and throughout were acting in accordance with their duties. Now remember, officers have duties and obligations, responsibilities to a legal system, a legal society. The man or woman does not. It's all based in constructive fraud, criminal conversion, and that's a fact, people. Trespass as well, because they trespass on the man or woman's rights and cause a controversy, and that's one of the legalese traps, controversy. The only main ingredient, and one upon which, in my judgment, this case resolves, is whether the obstruction of which the defendant was guilty was willful destruction, meaning deliberately did to obstruct them in their duties, right? If there is no crime, no harm, loss or injury, property damage, there is no crime. It's a nonsense. Willful in the context, not only in my judgment, means intentional, but something which is done without lawful excuse. And that is indeed conceded. Accordingly, the sole question here is whether the defendant had a lawful excuse for refusing to answer the questions put to him. In my judgment, he had. It seems to me quite clear that although every citizen, now this is another thing, people, citizen, this is an important word, community, citizens part of society, society is part of a corporation, has a moral duty, or if you like, a social duty to assist the police, right? There is no legal duty to that effect, and indeed the whole basis of the common law is the right for the individual to refuse to answer questions put to him by persons. Do you see that, people? No man or woman. This is the legalese trickery. The persons, and this is how in every situation, the legal system, legal society, they escape liability and authority, and to refuse accompany those in authority to a particular place, short of course of arrest. And in my judgment, there is all the difference between deliberately telling false story, something which, on my view, a citizen has the right to do, and preserving silence, judgment looked at in perfectly general way is not shown that the refusal of the defendant to answer the questions or accompany to the police officer. See how in the document and the case here, people, they're changing it from constable to officer. That's the trickery, because obviously this is done under an act. In the first instance, to the police box was an obstruction without lawful excuse. So the fact that this man never gave details had the lawful right to do so, because unless there is a crime of harm, loss or injury or fraud, property damage, there is no crime. And a man or woman is making a claim to be an injured party, there is no claim, there is no crime, and that's a fact. Now people, I hope you take notice of this, what I've just read. It's very important for people to understand there's a difference between legal and lawful. Legal is for corporations, lawful is for a man or woman. Flesh and blood, living, breathing, fact. A living man, living woman is a fact. Everything else here in the legal system, legal society, is trickery, fraud, trespass and criminal conversion. Anyway people, I hope you like this information from Anti-Corruption Scotland, and I hope you take stead of what I'm doing. There'll also be a copy of this on this channel to show the document. You can also achieve and get this document at #Anti-Corruption Scotland website. You can download it for free and take it, read it and learn. Anyway people, thank you for taking time to listen. I'll be back soon. Bye bye people, take care, be safe.